Good evening, everyone, and welcome to tonight's event, a gendered analysis of aggression and international law, with a particular focus on the Ukraine and Gaza. I'm delighted, as co-director of the Centre for Human Rights Law, to welcome you all here to SOAS this evening to what I hope will be an important and very much needed discussion about the role and the need for a gendered analysis of what's going on in perhaps two of the most controversial and difficult situations currently facing the globe. It is an absolute honour to be in the company of those engaging in a fireside chat for us this evening, but I'll leave it to my co-presenter to introduce the distinguished panellists that have joined us. Welcome to all of you, and welcome home, Gina. It's my role simply to open by telling you a little bit about the Centre for Human Rights Law, although I think many of you already know and have probably heard this spiel, so apologies in advance for those of you who are dear friends of the Centre. The Centre for Human Rights Law brings together students, scholars and researchers engaged in anti-colonial and anti-imperial understandings of international human rights law. Our aim as a centre is to facilitate discussion and provide research on contemporary international human rights law concerns from this perspective, taking as our starting point those from the SOAS regions of the Middle East, Africa and Asia, and their diaspora communities across the globe, as in addition to those acting in solidarity with them, as I'm sure our speakers will state they are tonight, in the UK and elsewhere. We aim to foster a praxis-oriented approach that brings into discussion hopefully the most interesting theoretical ideas in relation to human rights law currently in circulation with the practice of the law itself. So it is with great pleasure and great honour that we co-host this event tonight for what we think is a really important and timely report that I don't want to give away by saying too much in the introduction. Other than that, I think there is no other analysis that can be more important at this time than a gendered analysis as offered by the report that's been commissioned. I'm very happy and pleased, therefore, to begin by introducing our fantastic co-organiser and presenter of the report, and of course a founding director herself of the Gender Policy Portfolio that has resulted in this report from the New Lines Institute, the wonderful Emily Prey. Emily, over to you.
Oh my gosh, thank you all. Thank you, Michelle. Thank you all for coming. My name is Emily Prey. I'm the founding director of the Gender Policy Portfolio at the New Lines Institute, like Michelle said. New Lines is a foreign policy think tank based in Washington, D.C. that aims the Gender Policy Portfolio aims to bring gendered and intersectional analyses into international relations and foreign policy. You see the example of the gendered analysis of aggression report we have. I've also laid out some examples of other reports that we've published here that are all available online if you want to take a look after the event. And you are welcome, all of these reports you can take with you. I just wanted to say, first of all, thank you so much to Michelle and to Lutz and the Center for Human Rights Law. Thank you for sponsoring and for putting this on, and all of the work that goes on in the background, of course, and doing the heavy lifting. This evening's event is focused on a groundbreaking new report released by New Lines just yesterday, authored by Chinkin and Louise Arimatsu, who we have here today. It came out of a workshop in Berlin on conflict-related sexual violence about 2 years ago, where Christine and I met. And one of the outcomes of this workshop was that there was a need for a gender analysis of the crime of aggression, that was a gap in this space, and that no one had ever really written substantively on this before. And given the situations in Ukraine, Gaza, and elsewhere, it's become very important that policymakers and international lawyers understand the gender dimensions of this crime, especially with the recent announcement of a positive movement for a special tribunal for aggression for Ukraine. So I'm delighted to have both authors here today with us to discuss their report more generally, Professor Christine Chinkin is Emerita Professor of International Law, Professorial Research Fellow, and Founding Director of the Center for Women, Peace and Security at London School of Economics, and the author of numerous books and articles, many of which are assigned readings at SOAS. Dr. Louise Arimatsu is a Distinguished Policy Fellow in the Center for Women, Peace and Security at LSE, where she works on the AHRC project, A Feminist International Law of Peace and Security, and the ERC project, Gendered Peace. Her current research projects include A Feminist Foreign Policy and Women and Weapons. And we're very fortunate to be joined by Professor Gina Heathcote, formerly of SOAS, currently Professor of Public International Law at Newcastle Law School, who is an expert on public international law, feminist methodologies, collective security, the law and the use of force, and the study of gender, sexuality, and the law. And the event is moderated by Dr. Nada Ali, also our very own at SOAS, who teaches the use of force here and whose research focuses on international law and the impact of international institutions on developing countries. So without further ado, I would like to give it up to Nada and for the panel to begin. Thank you all so much for coming.
Thank you very much for coming, and I want to reiterate what Michelle said about this being an honor, and welcome back, Gina. And I want to thank Emily for obviously organizing, and the Center for Human Rights as well. Before we start, and I obviously have a lot of questions for you, I just want to say that this is great work, because I think sometimes we forget to theorize about international law, and I think theorizing about the law is very important, not just for academic purposes, but also for practice and to bring about a change in the world. So thank you very much for authoring the report, which I can tell you is very good. So, and to begin with, maybe I can ask Louise and Christine to talk about what comes in the report, actually. Yes.
Shall I start, Louise? Okay. First of all, thank you to the Centre and to SOAS for launching it. Is it not turned on? I'm not sure, but is it working?
I think mine is.
Yeah, that one is. Blue instead of green. Okay. And Emily, thank you. And sorry? Is that okay? Yeah. And thanks to the New Lines Institute for suggesting and doing it. As Emily said, it began over dinner, I think, at the seminar in Berlin, where we were talking about sexual violence and armed conflict. We were talking more generally about international law relating to the use of force, conflict related to, the whole of those sorts of issues. And I think you were talking about the Gender and Genocide report that had just come out from the New Lines Institute. And this conversation went on to, well, what about aggression? And, I've taught international law for far too many decades now. And I don't think I've ever taught aggression in an international law class. And it just seems suddenly a real gap that somehow within the sort of thinking, I think in all our discussions on the use of force when you're doing your PhD, we didn't talk about aggression, I don't think. We talk about Article 2.4. We talk about the prohibition of the use of force. We talk about if an armed attack occurs. We talk about breach of the peace, threat of the breach of the peace. Act of aggression comes in Article 39 of the Charter. But that's sort of where it stops. And I think sort of further that there is an assumption either that aggression is basically a political concept, not a legal concept. Everybody accuses everybody else of aggression. Yeah, Armenia and Azerbaijan each accuse each other of aggression. Israel accuses, obviously, Hamas, obviously Hezbollah, all of those. In turn, Iran, Lebanon, Syria all accuse Israel of aggression. And so we go on. Everybody uses aggression in that sort of political sense. And then I think you found, Louise, a quote by the American judge in the International Court of Justice back in 1984, basically saying, 86, Merritt's case, basically saying, the Security Council doesn't have to decide about aggression legally. It's a political concept. And yet, it's not. It's a legal concept. And not only is it a legal concept, it's a legal concept with a dual evolution. It's a legal concept both as an international wrongful act of state giving rise to state responsibility, it's a crime, international crime. And so we have these two branches of a concept of aggression, and yet it gets ignored. So that was really, go on.
I was going to say, I'm going to jump in here like we usually do. I think to sort of go back to when you first broached the idea of writing something on aggression, we had just completed our first draft of the book that we were working on, Gendered Peace. And we both suddenly realised that we'd not mentioned aggression in the whole book. And so this kind of reaffirms what you've said, that how we teach law is usually through use of force, etc. And aggression is kind of like the elephant in the room. And also at the same time, we've been looking at the other serious international offences within the context of gender. We'd spoken about that. We've written amici on the various issues of war crimes, genocide, crimes against humanity. But no one had actually really thought, including us, had not thought about aggression. And it was extraordinary as we started talking about it, how we hadn't. I've known Christine for very many years, and not once had I or Christine thought about it separately, nor indeed together. So it was kind of like a wonderful opportunity to say, think about it. And so, and it was kind of exciting. And so it's been a real pleasure doing it. I mean, difficult. It wasn't easy. One of the things that we really did also want to draw out was there was this emphasis on individual responsibility in much of international, in sort of academic engagements dealing with international offences, and there was a lot of writing around that area, but there was very little in respect of state responsibility, which is kind of like the bread and butter for international lawyers. You start with state responsibility, and that's what we really wanted to address. And I'm not sure that when Emily first came to us, she knew exactly what we were saying when we were saying, but Emily, you do realise we're going to talk about this. Okay, so that was the context.
So what have you talked about?
What did we talk about? We never answer. We never answer that. I was just going to say, though, even with the individual crime of aggression, it's amazing how many people seem to think it began perhaps in 1998 with the first inclusion of the crime of aggression in the Rome Statute. And as all of you know, it was then to be defined subsequently. And of course, it was then defined at Kampala in 2010. But of course, it has a much longer genealogy. The crimes against peace at Nuremberg is essentially the notion of aggression. And then we can even go back to the notion of the trial, never happened, but there was talk about the trial of Kaiser Wilhelm back in 1919. So, it actually has been there, for a very long time. So what do we actually talk about at the book? Okay.
The findings.
What's in the report? Well, because of our own ignorance, essentially, and the fact that we thought that aggression wasn't covered in mainstream international law, first part of the report, in fact, is a chronology of the evolution of aggression as an international wrongful act, and then as an international crime, and the consequences of having this dual characteristic under international law. So dual characteristic shared by genocide, for example. So that it can be a state, international wrongful act of state, it can also be an international crime giving rise to individual responsibility. So we first of all go through that. We raise the point that within the Charter framework, absolute discretion is given to the Security Council to make a finding of aggression under Article 39 as one of the triggers for Security Council action under Chapter 7 of the Charter. In fact, the Security Council almost never actually decides that there has been aggression once since 1990, and it wasn't in fact followed up by Chapter 7 action anyway. So if it's not been addressed by the Security Council, who has addressed it, answer being the General Assembly, the International Court of Justice through the concept of obligations owed erga omnes, and the International Law Commission through the concept of jus cogens. So there's been this sort of multiple bodies working on the concept of aggression. Then we get the Assembly of State Parties at Kampala coming up with a definition for the purposes of jurisdiction of the International Criminal Court, which essentially, not quite totally, follows the General Assembly definition, which was a Cold War definition back in 1974. So although the Cold War is well over by 1998, they still go back to that definition. So that's the first part of the report. Do you want to go into the next part, the gender bit?
I was going to say, okay. So what we, through looking at the material that we had at that point, what we came across was what we thought was a really useful understanding of aggression. And we kind of use this quote, and I quote here from page 13 of the report: aggression has been described as, quote, conduct performed under circumstances that result in consequences. And we thought that would be a really interesting way to think about gender through these various ideas, whether it be circumstances, conduct, and consequences. And so we kind of divided the rest of the report up into to thinking through along those lines. So structurally, it follows that. It was pretty difficult. And then the other thing that we were trying to do was, and it kind of links in with what this centre is about and what you, Nada, said about theory and practice, because it was all well and good to look at the theory of, but if you just do theory and you don't do the practice in terms of case studies applying to specific situations, you kind of lose your audience. And so, sorry. And the two cases that we'd done a lot of work on already were clearly Ukraine in the context of the Ukraine-Russia conflict, and also Palestine in the context of what was happening in Gaza specifically, but the West Bank. So we kind of took those two as case studies. We could have, and here I'm going to draw in. Should I draw in someone else? Okay. I'm going to draw in Nada too, because she was talking about Sudan. Yes. So we could have used Sudan. But, you've read the report.
I have.
Well, it's terrible. I'm going to put you on the spot.
No, I have. But actually,
and how useful is it in understanding Sudan?
So I think the question that I have is, what does a gender analytical tool brings to the study of international law? And how can it help us with understanding what is going on in the world right now?
I was enjoying the chat.
Sorry, Gina. It would all work. Okay.
Right. I think it's very much on. Right, mine is loud. Sorry. You want me to talk on gender?
Yeah.
What does gender bring?
What does gender and the use of force in particular?
Yeah.
When was our first conversation on that, Gina?
Yes, absolutely. It's a slightly weird scenario for me, because when I was doing my doctorate, probably the main people I spoke with was Christine and Louise, and it's a little bit like we've let you into our kind of private conversations that have been happening about 20 years now. So interestingly, I picked up that quote as well. The aggression is being conduct performed under circumstances that result in consequences, which is possibly the worst definition ever in some ways. Like, it says nothing about violence, and it's a really good lesson of how international lawyers think and talk about violence. They just don't mention it. But it is a really useful way of kind of thinking about the gender dynamics of aggression. And going back to your conversations with Emily, which I didn't know about, but also pick up on what I wanted to speak about, is one of the values of the report, is it takes us beyond thinking about conflict-related sexual violence as the way we do a gender analysis of any kind of state violence, or even kind of other forms of kind of mass violence. Not to say it isn't important that we talk about and recognise and name and speak out and try and prevent, prosecute conflict-related sexual violence. But we do know that when that becomes the focus, that it shuts down quite a lot of other conversations about gender and aggression. So this idea of conduct, circumstances and consequences allows us ways to thicken and expand the gender analysis, which is precisely what you do in the paper, so it's not like me being an expert. I'm just telling you what they wrote.
Do you know what was so relieved that you approved?
I don't know. So conduct. Well, okay, military conduct has gendered dimensions for the actors in the militaries themselves, in terms of the way military structures organise themselves and think about themselves and encourage their various participants, whether they're at the top of the hierarchy or the bottom of the hierarchy. It's gendered. We know that militarised forms of knowledge and practice and doing is gendered. So we can label military masculinities as part of the conduct of any kind of act of aggression. And I think there's more work on that element of, I guess, aggression, but less so the circumstances, which is the second part of this definition. Conduct performed under circumstances that result in consequences. Much, much harder is for the feminist international lawyer to talk about the circumstances that bring about aggression as also being gendered. And I think that's some of the work that you do in this report that's really important. That decision-making or justifications around aggression, when states say this isn't aggression, it's self-defense, or when states respond to an act of aggression, those conversations are structurally and symbolically gendered. So they're structurally gendered in the way that decision-making is enacted, and often law itself, but I think also symbolically. So an interesting and unfortunate and horrific example, actually, is just prior to Russia's escalation of aggression in Ukraine, because, of course, in 23, it's not the beginning of aggression; it's the escalation since 2014. But the way that Putin is speaking to Ukrainian, well, really to Russian citizens, but in a way that's really directed at people of Ukraine, uses very gendered, highly specific gendered language that mirrors domestic narratives, as in the way some men talk about the home, around masculine ownership and the violation of women, is replicated in the way that Putin speaks to Ukraine about how he's going to take back and violate Ukraine. And that's on record, public discourse that's highly gendered kind of construction of states' ownership or relationship with others, with other states, essentially, that this gendered frame of justification, so the circumstances that inform justification. So that's political discourse, but we see it mirrored in the legal discourse as well. And then, of course, the consequences, the post-conflict, but even during conflict, the consequences of aggression is always gendered, and it's gendered for everyone. I'm not here saying, well, women suffer more in wartime or because of aggression. Women suffer differently, and the gendered consequences and the gendered consequences of aggression need a much thicker analysis than looking for how a specific gendered frame or gendered individual is experiencing aggression. And I think what the report does is it unpicks those different layers in a really useful way, so that we see in total how aggression is gendered. But I think another part of the report, which perhaps we'll go on to, is that doesn't happen in isolation of other types of power. And perhaps if we only look at gender on its own, we kind of risk other sorts of kind of imposition of kind of civilizing modes of thinking about aggression as well. Sorry, did I go on too long?
Can I come back in? Because I think the really two very important words throughout the report that you've just used, hierarchy and power. Mm-hmm. Because essentially what we are talking about throughout here is the way that the military or the Putin you just mentioned, so the civilian authorities in a state use this language, discourse, assumptions of hierarchy and power to subjugate others. And very clearly what the gender analysis does through that hierarchy and of power is to collapse the various binaries. And so obviously men, women. As soon as that gets collapsed, we have to start challenging the other binaries. And international law is littered with these binaries, and they are all about power. So international, domestic, civilian, combat, come on, give me some others. Internal, external, intervention, non-intervention, war, peace, legal force, illegal use of force. We go on and on and on. And the challenge that is created as soon as we start saying, well, let's look at how gender has structured domestic hierarchies that then get replicated at the international level, taken into another country to destroy that country's sovereignty, territory, political independence, etc., is what we're really, talking about and challenging here. You want to jump in?
I was just going to add to what you've both said. I think this is the only one that actually works right at the moment. That it's interesting because you both pick up on this gender analysis, but as lawyers, we take it one step further too, because we're forever saying, how does law operate, and how is law actually articulated and implemented in a way that cements those binaries, those gendered norms, identities. So we've taken it one step further. But at the same time, we are also conditioned by a certain understanding of. And so there's this constant battle that we're going through as sort of feminist critical legal scholars, that we're doing this on multiple levels. Now, what's the benefit of that? Where does this take us? And I think what we're trying to do, what I'm trying to do, is to say, look, we all engage with our world through certain prisms that we don't realize already frame how we engage. And we need to take those, we need to unpack what's going on to see the world differently, because the world can be ordered in, and I use that word a little bit carefully, although I say order, but I don't mean order as in the ordering that we have today, but the world can be ordered in a different way that enables us to better achieve peaceful societies, non-violence, cooperation. And that's what we're trying to do throughout. And then to go back to the law and to say, how then can we understand the law in a different way?
So can I come back to your what you said, that you have written on peace before you have analyzed aggression? And I think my question is, has the report, or has doing this research on aggression changed anything that you have conceptualized earlier regarding peace, and basically what would a non-gendered definition of aggression entail, and what does a feminist peace really look like?
Small question.
Sorry.
We want to come back to Sudan as well. Do you want to go first?
No.
I don't think it changed our view of what a gendered peace should look like. I think maybe it added another dimension that what Nada's just referring to is we published a book which is going to be launched in a month's time, we could give a plug here, called Gendered Peace Through International Law. And very much part of our analysis in that book, part of it's historical, looking at feminist activism for peace since at least the 19th century, but also very much coming to the recurring themes of Gina's just really gone through it: militarism, militarization, how societies are structured to regard the military response to disputes, to disagreements between states, is normalized. Mm-hmm. We take it for granted. We think that's the right way to go. So when Russia invaded Ukraine, what did all the other states do? Decide whether or not to send weapons. Mm-hmm. That was, their starting point. Let's think about the military response to all of that. And it's the let's say, the normalization, the tolerance, the acceptance of those assumptions that I think we were challenging through gendered peace. And I think in this report, when we come back to militarism and militarization a lot through that, and we end up at the conclusion saying states constantly talk about how do we prevent aggression, and they don't talk about how do we have peace. International law never talks about how do we have peace. Peace never gets mentioned in international law except as breach of the peace, or occasionally peacemakers or peacekeepers or whatever. We don't have a sort of notion of peace itself. And the assumption throughout the Charter is that peace is the absence of war. It's not a positive of itself. There's a great comment in the Secretary General's 1992 Agenda for Peace, where it says we don't need to define peace. Everybody knows what it is. Well, really? International lawyers certainly don't know what it is. Can I just? Yeah, I've just finished that sentence. Then hand back to you. So what we say is that what societies do constantly, and what is normalised, and what they think is the manly, appropriate, strong thing to do, is constantly to prepare for war. So you buy your weapons, you engage in the arms trade, if at the domestic level you make sure you've got your guns, that is always the assumption, rather than turning it on its head and saying, well, how do we prepare and think for peace? And I think that starting with the concept of aggression perhaps just reinforced that thinking. But yeah,
all I was going to say is I think what we ended up also doing is thinking about how do we understand, or how does international law understand and engage with violence too? Which is the point that Gina made. But it's what is gets to define what is violence, and what is the appropriate response to violence, and how do we understand this? And I think that when you begin to sort of challenge those assumptions, you're actually then able to take your reasoning in a different direction. And I think that that's what we're trying to do with almost everything we write, to challenge the sort of the mainstream understandings of whether it's power, whether it's violence, whether it's in sort of peace or conflict.
And we also, no, go on, you go first.
Well, I was going to ask you a question actually, because I think one of the ways you do it in the report is you talk about spectacular and lived violence, or another kind of version of this is there's a lot of talk about international law as a discipline of crisis. Very famous judge wrote a piece on this, and I've been reflecting on this in something else that I'm writing. A lot of international legal writing about the crisis bit of her argument, and very little about the actual conclusion. In conclusion, this is Hilary Charlesworth's International Law, a Discipline of Crisis, and her conclusion is we need a law of every day, a law for the non-elites. And there's so little writing on that. Yeah. And I think part of this report, where you talk about the spectacular and lived violence and the distinction between the two, and the gender dynamics between the understanding of those two concepts, is really, really important.
Can I just illustrate that slightly further? Because the analogy that we took is domestic violence and violence, intimate partner violence, and so on. The definition of aggression that the General Assembly came up with in 1974 includes military occupation, however temporary. It doesn't have to be long. And of course, we've also just had the advisory opinion on the Palestinian occupation, in which the International Court of Justice says it's an illegal occupation. They don't say it's an aggressive occupation. I think we do, but they don't. But the analogy then that we draw is you have a long-term occupation, and in that long-term occupation, and we can equally look at Russia in Ukraine, the pure hierarchy, obviously, a people that are subjugated by the occupier. You have total control over movement, total control over what comes in, what goes out of the occupied territory, where you can live, when you can leave, even food. No, complete. And that is not looked at. It's thought of in terms of, oh yeah, you've got Geneva Convention 4 and the obligations on the occupier. But it doesn't go beyond that. It's just a breach of IHL, rather than looking at the fundamental what's actually going on there. And then you think about, say, long-term domestic violence, and the analogy is very strong. I mean, we've had quite a lot of discussion in this country now about coercive control, where whoever it is who is effectively carrying out the violence controls spending of the other person, controls who they can see, demands to know where they are going, when they're going to come back. Ongoing. And in both cases, it attracts very little attention until there's an explosion. When October the 7th is a very good example, as it becomes the spectacular, stops being the everyday of occupation, becomes spectacular, leads to the horrors that we have seen both sides. And again, the big issue in coercive control is very frequently when the person who is being controlled basically can't take it any longer and commits a major act of violence. And then the question all looks at, what is going on there. And so if we go back to the context, conduct, consequences, I think you can see all three of those very clearly across that analogy. And international law, as I said, okay, there's a law of occupation. How much has that actually been enforced? Let's look at Morocco and the Western Sahara, as well as Ukraine, as well as the occupied Palestinian territory. International law doesn't worry about it until it suddenly becomes an Operation Cast Lead, or what happened from 2023 onwards. And it just seemed to us that those analogies around what it is that domestic law or international law should be doing, looking at, responding to, it exposes the gaps very clearly. And then we also think, who in fact then, the public-private dimension, who in fact then is regarded as the legitimate member of the international community? Yeah, not the occupied. It is the occupier. Likewise, we all know that those who can commit domestic violence can be respected people within their community. How often do we hear, we really shouldn't prosecute them because it might affect, and I will now say his, because the bulk of domestic violence is committed by men, although not totally, it might affect his career. A sentence of that sort, we don't want to interfere with that public life. And so you get, again, that sort of public-private dimension which gets replicated in the occupied situation.
So, Louise, I'm gonna come back to the point that you mentioned earlier about Sudan.
Yeah.
So the point that Christine is making regarding the temporality of conflict. So basically, the fact that international law has the tendency to look at conflict as isolated incidents or like explosion of violence, while if you look at like a historical kind of view of conflict and how they come about, it brings about a better understanding of these conflicts, but also brings about policy implications regarding how to manage them and when to intervene and what to do about them as well. But yeah, I'm just allowing you to rope me into the discussion.
I was going to say, so carry on. This is the one problem that we have as international lawyers, is this kind of partition of time in this artificial way. And it is, we see moments in time, but not the in-between, and the in-between is usually the extended moments. And I think that some of the work that we do as critical scholars, okay, that says, we need to think about time in a different way, because unless we do, we can't address those explosive moments adequately. In fact, we should have been involved far sooner. Nonetheless, okay, international law holds us back from being able to do this, and maybe we should just resign ourselves to the fact that this is the limitation of international law, and recognize that it is a discipline, a practice that does only cater for those explosive moments. I'm not sure, but we need to have those conversations to understand what it does, and I think that the kind of work that a lot of feminists do highlight the gendered nature of how international law is structured, the sort of the foundations upon which it is structured limits us. I'm not sure what the answer is, but maybe you can speak to the situation. I mean, as I said earlier, you've read the report. To what extent does it does it give you a different understanding of Sudan as as an international law scholar?
I'm sure the lens will, yes.
Can I just come back in?
Sure.
You say international law only, so I've been saying as well as Kate says, I mean, it does try. I mean, we do have a human rights regime, and a human rights regime does try to say, this is what should be going on, all the time. But it aspires to it. Yeah. But of course, what we then also have is the fragmentation, and the silos of international law. So we have human rights, or we have IHL, or we have refugee law, and by the time they're all divided and fragmented so much, we lose again a lot of that. You're trying to come in. All right.
I can. I guess my thinking has maybe shifted over the years. It may be SOAS's fault, but I probably think if international law is going to be useful, it's got to be a different international law that is able to see different ways of doing law that aren't inherited from a very specific history of law that's from here, that's not just British, but European, Anglo-European, Western ways of thinking about law. And if we want to call it international, first of all, it has to understand law in its global plural dimensions, and in the absence of that, it will just keep repeating the kinds of violences that that you're critiquing in the report, that feminists have been drawing attention to, that scholars working on temporalities, post-colonial scholars identifying that gender isn't the only kind of thing that's going on here. All of those kind of repetitions need to be disrupted, I guess.
And of course, both of the case studies we talk about are both essentially colonial case studies. So, they absolutely replicate everything you've just said.
Well, probably I learned it from you too, Christine, so I shouldn't just say SOAS. I guess the only other... should I give it back? The only other thing I was thinking about, Christine's discussion of domestic analogy, which you talk about in here, I think also victim blaming and the gender dynamics of victim blaming. We've seen this writ large with both of these conflicts over the last few years, that you are making me be violent. I mean, that's such a kind of domestic violence. Law tolerates that story in domestic legal systems, and I'm always interested about how these concepts travel from one legal system to the other. They're not the same. The types of violence aren't necessarily the same, but there's a legal reading where there are some gendered concepts that are so ingrained in the way we think about the world that they're just invisible in the way we do analysis. And for me, unpicking that in law and that some of the work that you do here is really powerful. And so as scholars, students, you're great at doing that work too, so keep doing it.
Maybe it's a good point to ask the audience if they have any questions. Yes, for the panel, yeah. Thanks.
Yeah, these ones too. Who had it?
Yeah.
Thank you. Oh, it's really loud. I wanted to ask you. Oh gosh. Hold on.
That mic.
I can speak loudly, I think.
We've got one that works.
Okay.
Can you tell us who you are?
Oh God, yeah, sure. I work at ActionAid. I'm actually here with all of my ActionAid colleagues. Hi everyone. We're an NGO that specialises in women's rights, and in particular, we've worked both on Ukraine and Gaza. So I have found the talk really, really interesting. There was a piece. I work in comms, and for the last 2 years, we've been looking at the way that the language around not aggression specifically, but there's so many instances where the similarities are coming up when I'm thinking about it, in how we document what we believe to be abuses in the Palestinian territories, whether that's Gaza and the West Bank, and also because we focus on women's rights, we talk a lot about gender-based violence. One of the things that came up in the press conferences when kind of post-October 7th that pricked our ears, it was kind of Keir Starmer specifically as Prime Minister kept referring to Israel as her, she, her right to self-defence. And we found that interesting, obviously, as an organisation that works on women's rights, because it was almost as if it was being... the aggression was given a lens of this kind of almost like self-defense, the defenseless victim, and that this violence was happening against this woman, this kind of imaginary woman, and almost protecting characteristics of a victim, this woman victim, onto a state that is being accused of serious acts of aggression, including gender-based violence in prisons of Palestinian women, and also in Gaza. This is before October 7th. And I just wondered if you had noticed that and what your thoughts had been, because obviously it's interesting. Thank you so much again. It's really, really interesting.
No, I don't think we noticed that explicitly. You obviously did. So we don't always disagree. I'll make one comment, then hand it over to Luke, because I think Israel's really interesting on that, because I think we have a dual gender characterization. Because on the one hand, and we do talk about this, on the one hand, there is still the perpetual victim aspect of Israel. Obviously from the Holocaust, but obviously many, many more centuries of anti-Semitism and so on. So there's that aspect, and as you say, the right to self-defend, the right, and so on. But at the same time, I think there's very clearly a projection of the masculinity of here we are to protect our people, and we are going to, particularly when it's the Biden presidency, we're not going to just do what the US tells us, we're going to be ourselves, and we are going to be this strong protector. So I think there's almost a dual sort of aspect in the way that Israeli representatives themselves use that gender language at different times. You were going to answer differently.
So I'm going to confess that I am on X, and that was one of the things that I spent about 3 days tweeting about, because I found it really disturbing. I found it weird. Okay. And so it got me thinking to try and figure out what was going on, whether he was doing it deliberately in order to lay the foundation for the UK being able to take robust military action or when I say military action, I mean supportive action in providing for weapons. So, the UK was the protector, and we were paving that way. But at the same time, there's a part of me that was thinking, am I injecting too much strategic thinking into this? Is this like a reaction? And if it is, where on earth does it come from? Which I found as disturbing as if it had been thought out strategically. So I found it puzzling. What I did notice, obviously others also commented on it over the next couple of days, and then he did that a couple of times, maybe a month or two later, but then it was dropped. So he hasn't done it recently, so the that hasn't featured at all. And whether that was expressly drawn to his... this is me trying to figure out what the political class do in order to position themselves so that they can actually... Because he's speaking to the domestic audience. It's not about, Israel at all. It's about the domestic audience, in order to prepare, and then also thinking about more recently is sort of ventures into Crimea and, sort of wearing military gear and all the rest of it, sort of obviously takes us back to other prime ministers and what they're all doing. And this whole idea of how politicians, our leaders, take on not only the language but the whole, go through the whole performance of through dress and what have you, to prepare their domestic audience, so that when that moment comes that we want to actually launch or engage in violence, it is already legitimized by this process, and how long that preparation period lasts. So it's thank you for the question, but it is, it's like, be alert to these the performance, gender performance that goes on.
Yeah, Lutz from SOAS, co-director of Center for Human Rights Law. So we're witnessing a lot of what we may want to call hyper-masculinity in full display. So would you say that actually vindicates a gendered analysis as a response to that, or shall we see it as a defeat of feminist perspectives?
I guess it just underscores how powerful, and I think with the prior question as well, sometimes we think of gender as just benign. It's not. Like, it's a powerful ordering force, both invisible and visible. So I think the kind of threat of feminism, but also critical race theories, that at this moment in time, perhaps shows how important the work is, not a moment to step away, how important it is for all of us, regardless of what gender we identify with, to speak out in those moments, because we know what's being tolerated and what's being kind of normalised is a deeply racialised, gendered kind of history of organising the world that we need to be able to find safe spaces to speak about and to challenge, but also when that starts filtering into our everyday, I think we need to also be able to say, oh, hang on a sec, that's not okay, because that's what's starting to happen, is this like a permission to speak out loud, really deeply damaging discourses that might start in gender but aren't only ever just about gender, I guess, would be my response.
Shall I take one?
I've got a microphone, so I'll start off if that's all right. I'm Laura Hammond from SOAS. I wondered if, in thinking about the forms of aggression that are sort of not recognized by international law, something also asks us to sort of theorize the role of the state, because so much of international humanitarian law, etc., talks about the state as either the committer of the atrocity or the act of aggression, or being unable to prevent the commission of that act. And therefore, it sort of calls into question what are the limits of state responsibility, what are the areas that one can attribute to state power versus not state power, and then kind of takes us back to lots of thinking around the gendered nature of power and the way that violence against women has often been seen as being private and therefore not public and therefore outside the reach of government kind of commission, if you like. So there's something about sort of the act of theorizing aggression which calls into question what is the role of the state in that, and are we does talking about aggression actually encourage us to expand our thinking about the ways in which the state reaches into our lives in these different ways? So I wondered if you wanted to comment on that.
Do you want to answer your question also?
Hi, Nidhi, I'm SOAS alumnus. like taking from the hypermasculinity question, is there space for a mix of military masculinity, hypermasculinity, and the understanding of gender through race and ethnicity in the spheres of international law? Like, is there a way that these three things together in an intersectional fashion, how can they be negotiated within international law? Because from my very limited understanding, there isn't much space for a lot of nuance, because as we know, international law is made by the West, and there isn't much nuance in terms of keeping in mind the discrepancies that come in spheres of racialized gender or gendered race. So is there space for that nuance in modern international law?
Michelle, I wasn't sure whether you wanted to answer those two first. Sorry. Chair's privilege, I'm actually asking two. So the first question is in relation to the definition of aggression that you've outlined and the notion of conduct, consequences and circumstances. If you were in charge of defining aggression, would you stick to this? Would you incorporate, as you've mentioned tonight, coercion as one aspect in law that you might want to look at, or might there be others? And my second question I've forgotten because I'm hungry. So I'll have a think. And yes. You've highlighted very importantly the binaries in international law, and particularly the notion of war and peace, and the lack of understanding in international law by international lawyers on peace generally. And thank you in advance for this wonderful book that's coming out. One of the things that has upset me over the past 20 years is the ongoing prevalence of the discussion and regulation of the war on terror. But of course, war on is a very strong narrative generally, right? War on drugs, war on terror, war on everything. Is there a counter movement or a counter culture that could be drawn from peace for? And should we start thinking about peace for? And would that be one way of responding to the binary, or is it actually just co-opting the binary? And stop, Michelle, before you start, because that wouldn't work. Cheers. Thank you.
You start, Gina.
I'm going to leave the state one. I think Louise can do that one. I'm going to do the hyper-masculinity, racialised understandings of international law. I think if I understood your question right, is there a space in international law? There has to be. But I think also one of the gaps in gender theory, at least amongst international law, is a thick kind of concept of the diversity of masculinities that exist, and the necessity for us not to let dominant, violent masculinities define masculinity. There are so many, and within any community, but also if we look outside Western modes of doing and being and performing, or understanding gender as well. So I think there has to be, but there isn't. So I think I kind of agree with what I see is coming under your question.
Can I jump in there? Because I did want to add something on that, because, so it's intersectionality. We engage with that in the other work that we've, the book that we've produced. But and this is the difficulty of public international law. Because intersectionality I see as having found its basis in this idea of the individual. So it becomes easier, not easier, it's more developed in the idea of the intersection of whether we talk about gender and or race, or gender ethnicity. So we've done a lot of thinking there. What we haven't done much thinking of is that the idea of intersectionality in public international law. How can we use that understanding at the individual, to bring it to the state level? I think that, and this is one reason why we're struggling to, but there's like a tiny entry point that I'm beginning to think that maybe is through the idea of gender apartheid. Okay, because here we're beginning to talk about state responsibility. Okay, and I'm thinking of in the context of Afghanistan and how we have this issue of the discrimination at the level of the state that's founded on gender, but it also comes, okay, through the silence of international law with race and potentially ethnicity. So in a way, okay, it's through those silences that I think it's your job, sorry, I'm retired now, okay, but it's your job to think through this and think about different ways of understanding intersectionality through international law and sort of develop that thinking more, because there's something there that's worth pursuing. Okay.
Can I just add on to that? I think you've also answered the question about state responsibility, at the same time, because obviously those two link very much, particularly if we try to think about gender apartheid, which is very much about state responsibility and the role of the state. And I think it also adds another dimension, which of course is the importance of theorising from the global south. I mean, South Africa in particular is obviously leading a huge amount, and at the public international law level, through the case, before the ICJ and so on, and other countries, states from the global south, who are not prepared to accept the framing that they have inherited, imposed upon them from the north. So I think we're seeing that shift, both politically and conceptually and legal analysis. I was going to add 3 words to your definition of aggression. Coercion, violence, and let's stop talking about legal and illegal. It can be aggressive, even if it's legal, yeah? And we are so tied up in international law with, is this self-defence under Article 51? And if it's not self-defence under Article 51, unless the Security Council's authorised it, I think we can dismiss that at the moment, it's therefore illegal. So we're so on the idea that if it is legal, because we can get it into that Article 51 framework, it's not aggression. Well, that doesn't make any sense. It can be just as much aggression, even if legal. So yeah, I would also move away from what they've done in both the GA definition and the ICC definition of listing different things that are aggressive. I think as soon as one starts, they say it's a non-exhaustive list, but it does start to control, as we all know. What have we not answered? So, peace. All I'm going to say on that one is to quote Di Otto some years ago, who said, well, supposing we called it the Peace Council instead of the Security Council, how would that have transformed thinking there? And I think that that's a really good starting point. But you wrote about that in the Peace and Our Feminist Conversations book, where you say that you want to try and teach in international law of peace. Nobody's interested. So
actually, SOAS has canned that course since I left, haven't they? They only run the armed conflict one. Is that right, Lutz? Tell me, there used to be one on gender, peace, and international law. Is it still there, Eddie? Yes. Did you get rid of it?
It's still there.
I think that kind of maybe. Well, now I've forgotten what I was going to say. Teaching peace. Actually, 2 things. I think this sort of answers Laura's question a little bit too, and Michelle's at the same time. It's kind of not our role in the West to start teaching about peace. I always wonder why the definition of aggression or like post-conflict initiatives, they don't start with, let's go back to the people that have lived through this and ask them what worked, what didn't work, what would be different, and what does it mean to experience aggression or to try and build peace? Because we keep just replaying certain different ways of doing this. And on a moment of hope, also to use the language of Di Otto, if you look at the Security Council over the last few years, it's a very small change, but we now talk about the E10, which is the elected members of the council, and that's because the E10 are up to stuff. We talk about the P5 quite a lot, permanent members, how they veto everything, how they stop everything, how they change the discourse. But a couple of things have happened. So we don't just have the E10 often working together to change the language. They're now literally grabbing the pen. So the pen holders used to only be one of 3 permanent members of the Security Council. Now the E10 take the pen and help draft resolutions, so their language starts getting in the resolutions. This is small states, not necessarily economically powerful states. We also talk about the A3+, which is the African states on the Council, joining together to transform the language of the Council. And in Women, Peace and Security, we know we had the tri-presidency of 3 small states coming together to ensure that when they were in the presidency, the language of women, peace and security came into different situations on the Council. So this is states not from Europe, or only occasionally. Small states, often states with histories of conflict or post-conflict, long sort of legacies of post-conflict scenarios, coming together to organise differently. Now that might not change the resolutions, but it's starting to change the actual practice of the Council. And it also gives us as international lawyers really valuable resources about state practice well beyond the states that have informed that in the past. So I think that kind of talks to your kind of question, Laura, about state responsibility and states in the Global South taking a different kinds of responsibility and a literally different way of doing this, which is maybe kind of partial answer to Michelle's. Is that a nice hopeful?
The optimistic.
Thank you for this discussion. Just for the Security Council and the language and the resolution, I'm from Palestine. So the language and the text of the resolution sometimes ignore the specific context of the cases. For example, when we are talking about the UN resolution 1325, it ignores the situation of occupation and later on the genocide, and they consider all the women in the conflict areas are the same and have the same condition, and which is not the case in different places in the world. And for the aggression, and I believe that there would be a comprehensive definition that the form of aggression it could include occupation, genocide, colonialism. These very important that the aggression it should not be limited to military aggression or military occupation or military attack. There are other forms of aggression depending on the context, but the power relations in the world control the use of those legal terms.
I think we all agree. Fine last word. Absolutely.
We have time.
Yes.
Yeah. Thank you, Aisha. I'm an MA in Gender Law student here and also work for ActionAid. I'm loads of us here today. My question's a bit different to ones that have come before. It's looking at military technologies, and I know, Gina, you've written a little bit about this. I'm thinking about how kind of we've seen AI for surveillance in Gaza and also for misinformation in Ukraine and Russia. The question is kind of like, how would you see advances in military technologies changing and interacting with these dynamics of masculinity, hypermasculinity, representations of femininity? Any thoughts on that? Thank you.
Yeah, you're the weapons person. I've actually written quite a lot on this area. I used to do a lot of work on cyber, also sort of emerging technologies, weapons, etc. I think, okay, so I'm not quite sure even where to go with your question, because it's such a vast area, and it is just, I feel that especially the legal community is being left behind right now because of the cutting edge technologies that span, as you say, across the whole spectrum of digital, sort of technologies from digital technologies and surveillance, and we saw the cameras and the AI working in Gaza. We also see the use of new technologies in the field. And we cannot keep up to those developments as lawyers. So I go back to, sort of the basics of law that might help us, but they're deficient right now. They are absolutely deficient because we are battling, and I hate to use the word battling, but those of us who are even trying to protect what we had, okay, are faced with the onslaught from multiple directions, and I'm not sure where we're going to end up right now. I'm really concerned by the fact that we have, institutions, private institutions that are interconnected with elites within the public sphere who control information. And we see this across the board in every single sphere of our life. It's going to be pretty difficult for all of us because, as I said, we're battling narratives as well as how we think and how we address problems, how we understand law, how we understand situations, whether it be aggression or not, how we, I'm not sure. It's an inadequate response, but the challenges are pretty enormous, and I don't think we see the half of what's going on. We are just seeing literally the tip of the iceberg, and even that is concerning. So, how, what do I say? I'm not sure. I really don't know what the answer.
Okay, I'll do hope. So, yeah, no, I agree with everything Louise said, but also technology is also a side of resistance, and it's not only states that use technology or private companies, but maybe think about like the tremendous impact of forensic architecture at Goldsmiths has had on the way investigations are conducted, and the way that we can get kind of understanding and records of what's happening and piece it together in different ways, even now in the court, right? I think that's... but there are other groups that aren't necessarily in universities, but technology is also used by many people as a space of resistance. And I think kind of digging into that and not letting it just be something that we have to be scared of. We're already all embroiled in our kind of relationship with technology, and letting that just be like a meta-narrative. Well, it's, maybe we also have to look at the spaces where people are already doing quite different things, humanitarian actors. Probably Laura Lutz, you know much more about how technology is used in the field now to kind of collate evidence, for example, which is not going to stop it, but actually those. So maybe think of it also never just as one thing, I guess, if this is what you're researching. Mm-hmm.
I'm feminist. No. I agree that the issue of resistance comes up, and this is another way in which we might collaborate, and it's a form of solidarity and all the rest of it. However, I'm such a skeptic in this area. I'm not entirely convinced that it will help us a little, but I don't think we should be blinded to the fact that somehow our endeavours are at the same level as those of corporations and states. We are well behind, and it's tough. And sometimes I think, it's those. I go out on the protest marches every other week, every 3 weeks or whatever, and it's in those spheres that we're actually going to build solidarity far more effectively than through these technologies. Because technology, the spheres, the digital spheres, are so already controlled that I'm not entirely convinced that we're going to win in those spheres. I think it is in these spheres that we win, okay, that we build those bonds.
Can I add something that's nothing to do with technology at all, but to go back to your point? But it does sort of link up with the building of solidarity. We shouldn't get too tied down onto the Security Council. There's lots of other institutions of international law. And you said, 1325 doesn't mention any state, and it doesn't mention it's very context unspecific. But at the same time, we have the CEDAW committee with General Recommendation 30, which goes through all of these issues. It goes through occupation, it goes through genocide, it goes through everything, and puts it all into the context of women's rights, women's human rights, and so on. We have, whatever the court is going to come out with. There's all the various civil society interactions with the international institutions. I mean, there's a whole range. So yeah, the Security Council is very disappointing in its language, although, as you say, there are glimmers of hope there. But we shouldn't just... I mean, the General Assembly is taking back a lot at the moment and is continuing to do so. And I think we have to look at this much broader. It's breaking down the silos again, is what it really is coming down. For resistance and solidarity, it's got to be find your allies where you can, use those, and really just work together.
I think the question, maybe these questions are all geared towards asking whether the international law of the future is going to remain state-centric. Because what we see right now is lack of protection for civilians, aggression really mainly against civilians, states not being responsible for civilian suffering. So I think it's that anxiety. And it would be good to think that would not be the future.
I think you've just answered. I was just going to say. I think you've answered. You've said it.
Actually, in gender peace, this is an issue that we cover, and we're actually hopeful. So,
well, no, you are. You're the more hopeful. But no, you are. I mean, really think through where are the entry points for transformation, and how can that transformation come. But at the same time, go right back to where we started this evening. This is why we emphasise state responsibility for aggression. States are too anxious to say, oh, no, it's individuals, got nothing to do with us at all. International criminal law, which we hailed in 1998-2000 as this great breakthrough with the creation of the International Criminal Court, has actually let states off the hook far too much. And we also, at the same time as trying to think about how to transform international law away from the state, have to also say, look, you have got responsibility, and think about ways of ensuring that accountability.
So basically turn state-centrism on its head.
Yeah.
So let's remain state-centric.
With the smaller states and those that are really fighting that battle very much.
All right. Well, thank you very much. Thank you very much. Thank you for the report, but also the discussion. This was very enlightening. And thank you for attending.
Thank you. Great questions.